Everyone who builds wealth faces one problem: how to protect it from taxes, lawsuits, and the unexpected. But what if a legal tool could make your assets private and protected without government registration? This tool is the Express Trust. Its power is in its privacy. A trust agreement is not a public document. It also lets your assets completely bypass the slow, expensive, and public court process called probate. We will break down what an express trust is, how it legally shields wealth, and the vital distinction to make it work. What is an express trust? It's a legal relationship. You, the settlor, give assets to a trustee to manage for beneficiaries. To be legally valid, a trust requires three certainties: a clear intention, identifiable assets, and specified beneficiaries. This is why registration is seldom required. These trusts are based in common law, not state statutes, avoiding public filing. This structure provides instant benefits, bypassing probate, ensuring privacy, and allowing seamless management if you're incapacitated. You also get precise control over when beneficiaries inherit, and can even set conditions for distribution, like reaching a certain age. These benefits are powerful, but they are only the beginning. The real strength of a trust is found in one critical distinction. But how does a trust actually shield your assets from a lawsuit? The answer depends on if the trust is revocable or irrevocable. A revocable trust is flexible. You can change it any time. But this is its weakness. Since you control the assets, the law views them as yours. An irrevocable trust is different. You give up control and ownership. The trust itself becomes the legal owner. This is the key. Think of it like this. You can't be forced to pay a debt with money you don't legally own. By transferring ownership, you legally empty your pockets. The trustee you appoint now has a fiduciary duty to manage the assets by your rules. They must act in the beneficiary's best interest. So, the secret isn't just having a trust. It's using an irrevocable one to legally separate yourself from your assets. Let's see how this works. Example 1, the Spendthrift Trust. A clause can stop a beneficiary from losing their inheritance to creditors. The trustee manages funds, but the principal is untouchable. Example 2, Domestic Asset Protection Trusts. Some states, like Nevada, let you create an irrevocable trust where you can still be a beneficiary and get distributions. Also, create the trust in your lifetime, an inter vivos trust. A testamentary trust from a will must go through probate first, defeating a main benefit. Imagine a family business. Place it in an irrevocable trust to pass it on without being broken up by estate taxes or creditor claims. The legacy is secured. The power is clear, but trusts are not magic wands. There are critical rules and mistakes that can render them completely useless. About that bulletproof trust? Here's the catch. You can't use it to commit fraud. It protects against future creditors, not debts you already owe. The number one mistake that kills trusts? Failing to fund it. The paperwork alone does nothing. You must legally retitle your assets into the trust's name. This means changing your home's deed from John Smith to the John Smith Irrevocable Trust. You must change the owner of your accounts. The trust must own it. Another legal trap is the doctrine of merger. You cannot be the sole trustee and the sole beneficiary. If that happens, the trust dissolves and protection vanishes. So, it must be irrevocable, properly funded, protect against future creditors, and have a valid structure. Now, let's connect all these pieces. We said trusts don't need public registration. We also said irrevocable trusts remove assets from your ownership. Combine them and you get a private financial fortress. We also talked about setting specific terms for inheritance. Add a spendthrift clause, and you protect wealth not just from lawsuits, but from mismanagement within. Finally, think about funding the trust by retitling assets now. They are outside your personal estate later. This is exactly why you avoid probate. The evidence is clear. A properly structured, funded, irrevocable express trust is a supreme legal tool for preserving wealth, privacy, and legacy outside public systems. We've covered the power of non-registration, the vital difference between revocable and irrevocable, and the fatal mistake of not funding your trust. This isn't a loophole. It is a long-standing feature of common law designed to give you control over the assets you have worked your life to build. However, as we have seen, the details are critical. This is not a do-it-yourself project. Mistakes in drafting or funding can have catastrophic outcomes. If you are serious about protecting your wealth, consult a qualified estate planning attorney who specializes in trust law to see if this strategy is right for you.